Greetings, this is Michael Swain, Executive Director of Freedom of Religion South Africa, and I'm here with 4SA's in-house attorney, Daniela Ellerbeck. We're speaking to you today because we are facing perhaps the most severe threat to date to our religious freedom and even to the future of our democracy in the form of the National Health Act's draft regulations. Now, these regulations, which will replace those that have been issued under the state of national disaster, are open for comment only until Friday the 15th of April 2022. If we do not object and push back against them, we will be ruled indefinitely by ministerial regulations with virtually no effective oversight by Parliament or the courts. Now, you may well be aware that during lockdown it has been evident that there is a consistent pattern of unfair discrimination against the religious community. From the outset, religious workers and religious organisations were not included in the category of essential workers. Despite numerous letters to the President, the COGTA Minister, and a legal action in the High Court, this is still the situation. Religious gatherings were branded as super spreader events without any scientific proof or evidence. Religious gatherings have also been and continue to be subjected to more burdensome sanitation, record keeping, health and hygiene protocols than any other sector of society. And religious gatherings were shut down while casinos, fitness clubs, etc. continue to operate. And at the same time, helicopters, rubber bullets and batons were used to break up prayer meetings while party political rallies and other events continued without any sign of police interference. Today, with the appearance of the Omicron variant of COVID-19, government can no longer argue that they require all these draconian executive powers to save lives. According to Professor Shabir Mahdi, Professor of Vaccinology at the University of Witwatersrand, we now have 80 to 85% of the population who have developed protection against severe disease and death. Globally, countries are rolling back their COVID-19 regulations, no longer limiting numbers at gatherings or requiring mask wearing, because they recognise that these measures are no longer needed and the collateral damage for continuing them is just too high. Again, and in the words of Professor Mahdi, we see no reason for the continued use of this legislation nor for the National Coronavirus Command Council. It is therefore extraordinary that government is now seeking to expand its rule. It proposes exiting the state of national disaster, but intends keeping and even expanding its powers in terms of regulations made under the National Health Act and on the pretext of continuing to manage the COVID-19 pandemic.
Now, looking at these draft health regulations, which are open for comment only until Friday the 15th of April, we need to understand that they require no parliamentary oversight, nor does the minister need to give reasons for any decisions or future regulations that are made. This effectively grants government the same extraordinary executive powers they've had under the state of disaster indefinitely. Unless we all speak up and make our opposition heard, this will shortly become the new normal. Now, here are some of the lowlights. The Minister of Health has the sole discretion to list any disease as a notifiable medical condition, or NMC, without any consultation with the public and or Parliament and or any requirement to give a reason for such a listing. In drastically limiting our constitutional rights, the draft regulations simply consider the risk of transmission, not the actual severity of the disease. Something as inconsequential as the common cold could theoretically, therefore, be listed as an NMC. The draft regulations also impose the same degree of limitation of human rights irrespective of the severity of the disease, and can do so indefinitely as long as something is listed as an MMC. There is no defined criteria or process for a disease to be declared an endemic, let alone a pandemic. The regulations impose mandatory medical examination, hospitalization, quarantine, isolation, and treatment for merely having been exposed to someone with an NMC or for being simply suspected of having contracted an NMC. Treatment is undefined and could include mandatory vaccination or compulsory quarantine in a state facility. You must show proof of vaccination if you wish to attend any gathering over 1,000 people indoors or 2,000 outdoors. Now, this is a gross and unjustifiable violation of the right to religious freedom guaranteed by sections 15 and 31 of the Constitution. Failure to comply with these provisions is a criminal offence with the sanction of an unspecified fine and/or 10 years in jail.
So it is absolutely vital that you act now to make your voice heard and to push back against these draconian regulations which will centralise and confirm power in the hands of an unaccountable political elite. Again, the deadline for comments is Friday, the 15th of April 2022. To help you take action, 4SA has teamed up again with Dear SA to make it quick and easy for you to send an individual submission to the Department of Health. The main reasons to object are on the landing page, and the form can be completed with a few easy clicks.
Act now and click the button in the description below this video to send your submission. Then share this video with your friends, family and contacts to make them aware of this danger and so that they too can be equipped to make their voice heard. Thank you for taking your stand for faith and freedom. Good day, this is Daniela Ellerbeck, the Legal Advisor to Freedom of Religion South Africa. Remember to like and share this video and then click on the subscribe button to make sure you never miss our video updates on vital religious freedom issues.